And I want to call on Dr. Conor from the Faculty of Law, University College Cork. Dr. Manny, very welcome.
Thank you, colleague. Committee members, I'm grateful for the opportunity to address this issue today, and in my brief discussion I want to focus on some of the issues concerning competing rights which were already discussed this morning in the context of the Irish Constitution, and also to say a little bit about international human rights law. A lot of the discussion in this area is informed, as you're aware, from the earlier discussions by the Supreme Court decision in the IoT versus B case from 1998, in which the Supreme Court addressed the competing rights of adoptees and natural parents. The Court recognised that the adoptee has a constitutional right to identity. The Court also recognised that the natural parent has a constitutional right to privacy. And the Court stressed that neither of those rights are absolute. Each of them may be qualified to an extent by the other. Now, I think much of the discussion in this area where constitutional concerns are raised about laws of this type are based on this case and based on what I would see as a greatly exaggerated concern about possible constitutional issues. And much of it is based on focusing on the outcome in the IoT case rather than the principles established in the case. The outcome was that the case ruled in favour of protecting the mother's privacy, but the Court did that in a context where there was something of a legislative vacuum. What this law is seeking to do is to fill that vacuum, and what the Court had to say about laws enacted by the Oireachtas on issues like adoption, identity and tracing was that it is for the Oireachtas and not for the courts to establish how to balance competing rights, how to deal with sensitive matters of social policy, and the courts will, in the vast majority of cases, unless there are extreme consequences, defer to the balance struck by the Oireachtas. That's the key message set down in IoT versus B, and that's a message which we've seen repeatedly emphasised in subsequent decisions of the Supreme Court. Some recent examples would include a challenge against the law on the age of consent, a challenge against the law criminalising assisted suicide, and a case involving the allocation of parentage in surrogacy arrangements. In all of those cases, the Supreme Court stressed the complex social matters should be addressed by the Oireachtas and not by the courts. So for that reason, I think the key message to take from the IoT case is that it is up to the Oireachtas to legislate in this area, to reconcile the competing rights. Any future court would be exceptionally slow to second guess that and to strike down any law which is enacted in this area by the Oireachtas. So I think that's important to stress. So, aside from the fact that the constitutional impediments, I think, are greatly overstated, there's also a legal imperative, indeed, to enact laws of this nature, and that legal imperative derives from Ireland's international human rights law obligations, in particular the UN Convention on the Rights of the Child, and to a lesser extent the European Convention on Human Rights, both of which recognise the right to identity as a key right recognised by international human rights law. There are various degrees and levels to that right, but the minimum core is to know one's origins, parentage and conditions of birth. In other words, access to a birth certificate as a minimum core. So Ireland's international human rights law obligations indeed require the enactment of this legislation, and I think as long as the legislation remains unenacted, then Ireland is vulnerable to findings by international human rights committees such as the UN Committee on the Rights of the Child that we are in breach of our international human rights obligations. So far from there being a rights-based reason to not enact the law, I think indeed there are rights-based reasons to go ahead and enact this law forthwith. Finally then, just briefly to mention that there is equally an issue of consistency internally within Irish law. Identity is strongly protected by the Children and Family Relationships Act in the context of donor-assisted human reproduction. If it is important in that context, it is equally important in the context of adoption, and indeed far more people are affected. So if we are to be internally consistent in our laws, this law is necessary to bring the area of adoption in line with the area of assisted human reproduction. If the law is to be enacted, I think it's important that it's done properly. I mentioned the idea of the minimum core of the right to identity being, at the very least, a bare minimum of access to a birth certificate. And I think the notion that the law would potentially qualify that bare minimum and create exceptions to that is something which I think is unfortunate. I think if there is legal advice there that suggests that it is constitutionally necessary to qualify that, I'm not sure I would agree with that advice. I'd like to see it in more detail. I think ultimately, if you have a right which says birth certificate as a bare minimum, not files, not medical history, not contact information, That is a bare minimum, and I think any suggestion that that be denied on the basis of a potential threat to safety, especially in a context where there is extensive civil law and criminal law, in particular the Non-Fatal Offences Against the Person Act, which provide other protections in those circumstances, I don't believe there's any constitutional reason or indeed any justification for qualifying that bare minimum right of simple access to the birth certificate. Balancing it, of course, in the context of contact information, that makes more sense. But when you come to just the bare minimum of the birth certificate, I don't believe that that is necessary. Rather than defining this idea of compelling reasons, I would submit that the preferable course of action for just that level of access to information would be simply to remove the qualification altogether and remove the need to define that idea of compelling reasons. Finally then, just something which was mentioned earlier on in the earlier discussion, and which I mentioned in my written submission, is just the issue of step-parent adoption. I won't explain all of that in detail again because people are by now well aware of what it involves, but just to note that there was a commitment given during the debates on the Children and Family Relationships Act that issue would be dealt with in this Act. The bill as it stands doesn't propose to do that. There is a very simple solution available based on the English legislation, so a simple, short, miscellaneous provision modelled on the English legislation included in this bill could resolve that issue. Last year, of the 112 domestic adoption orders, 74 of them were step-parent adoptions. So I think this is an issue which needs to be addressed. It can be very easily addressed, and this bill presents an opportunity to do that. So conscious of time, I'll leave my submission there for now. My written submission goes into more detail on all of those points, and I'm happy to deal with questions later on. Thank you.